At 10 o'clock a.m. and we're going to get started. Welcome everyone to Hawaii REBI Chapter's first virtual general membership meeting. Yay! And I'm here. This is Crystal Lancaster, your Director of Industry Relations, and I'm here to introduce to you your chapter president for 2020, Fuku Puckett.
Aloha everyone. Welcome to Hawaii REBI Chapter's first, as Crystal mentioned, virtual general membership meeting. Our featured guest speaker today is Andrew Nguyen. He's the legal counsel of the Hawaii Association of Realtors Legal Hotline. And as Crystal indicated, my name is Fuku Puckett. I'm the current REBI president of the Hawaii REBI Chapter. If you're not a member of REBI, we welcome you to today's event. Our Real Estate Business Institute chapter in Hawaii is one of the most active chapters in the United States. If you're interested in finding out more about us, go to our website at rebihawaii.com. That's rebihawaii.com. We are a local membership of CRB, SRS designees and candidates, and RENI and CRETS certified agents. Before we start, I want to introduce our sponsor for today's event, Leonard Loventhal of Guaranteed Rate. Take it away, Leonard.
Thanks, Fuku. Good morning, everyone. I'm Leonard with Guaranteed Rate, and we are first off very pleased and very grateful that we can continue to support and sponsor the REBI group, CRS, all the groups that we've done in the past live. And although we're in a new normal now, we continue to be able to support the home buyers and all your realtors with your needs, mortgage needs. Guaranteed Rate has been around in Hawaii now for about a little over a year and 4 months, coming up on a year, maybe year and a half. And we've had a very successful launch thanks to a lot of your support. We are completely digital, as well as having the advantage of our physically located loan officers on Oahu and on Maui to meet with clients, social distancing, of course, as needed. But again, we can do 100% of our work digitally, online, with the technology that our company provides us. And it's been a very good start. We've been very pleased with the results, and we look forward to doing these sponsorships virtually as well as helping clients going forward. I would also like to introduce two other loan officers that are with me. Between the three of us, we are your sponsors for today, your specific sponsors. So first off, I would like to introduce DJ Dole, who most of you know probably. And DJ, can take it away and say a few things.
Good morning, everybody. Hope you're learning to work within our new confines and requirements due to COVID. As Leonard mentioned, we are really prepared for this. I think we're prepared for it a lot earlier than some other companies with respect to the tools that we have necessary and available to us to be able to kind of have a hands-free loan transaction. So in addition to our insane application that they can fill out online, we've got a lot of marketing tools for you folks. We've got a co-branding website, or a co-branding program, sorry. It's called Gateless. And I don't know if I've mentioned it to you folks before, but it really allows you to expand within your marketing efforts. And one of the things that it has is the ability for you to create a website for any listing that you have. I know that I do this. When I go in and I look up a property, I type in the address in Google, and the first thing that comes up may be a prior agent who had that listing, or it may not be your information. If you create a website specifically for that property and you use it right and set it up right, you can be the one that's going to be the first thing people are going to see, and it's going to go directly to you. Not only that, we can do flyers and real-time rates. So when you're looking to see what rates are, you can go on this program and you can look up the rates and see where they are exactly. So I'm going to have a list of everybody that's on the call today, and I'll forward you a link to it. And if you're interested, go ahead and sign up, and you can kind of see what we have to offer you folks. Have a great course, and I hope you enjoy the day.
Thank you, DJ. I would secondly like to introduce Kini Lang, another one of our loan officers with Guaranteed Rate. Kini?
On the Zoom meeting. One of the things I'd like to share with everyone is our loan program. We have a really robust VA loan program. We can go up to $1.5 million, 100% financing, or we can even go up to $2 million, which is as little as 5% down for vets. So it's an amazing, tool to have for buyers. It just enables them with, to purchase at a very high amount without having to put any down or little down at all. So we have other programs that we offer that are very competitive. We do lots of conforming loan programs. You can do jumbo, leasehold, co-op. So we're very diverse in those programs. Yeah, so again, like DJ said, if you want a pre-approval, you can do it through Gateless, and you can immediately have the borrower print out their pre-approval too. So it's really robust technology that we offer at Guaranteed Rate to make the process very seamless and easy. Yeah. Thank you again for having us. Leonard, I'll give it back to you.
Sorry, Leonard, your
Sorry. Sorry. My bad. Before I turn it back to you, Fuku, I want to thank DJ and Kini for joining on with me and sponsoring this webinar. Rates are actually all-time lows that we've not seen these rates in such a long time or ever. So please take advantage of it. Please reach out to any of us with any questions or anything. We'll be glad to address your questions and of course help clients. So thank you very much for the opportunity. And with that, I'll turn it back to you, Fuku. Thank you.
Thank you, Leonard, and also DJ and Kenny, and also for you guys' continued support. Today's speaker is Andrew Nguyen. He is the legal counsel for the HAR Legal Hotline. Andrew grew up in San Jose, California, and attended UC San Diego. Prior to working at HAR, he was the lead attorney and committee clerk for the Hawaii House of Representatives Judiciary Committee. Today, he's going to cover the hot topics he receives from the hotline. I guess he gets a lot of calls. But before we begin, this session will be recorded. And if you have any technical issues, please type them in the chat box and our staff will assist you. Lastly, we'll be taking questions from the Q&A box at the end of Andrew's presentation. Please join me in welcoming Andrew.
Morning, everyone. Thank you, Fuku. I've been talking with Crystal that I kind of have everything set up in different segments, different topics. So if you guys have questions on the relevant topic, and Crystal and some of our other staff who are monitoring the Q&A take a look at it and they see a relevant question, they may go ahead and jump in during that section rather than waiting all the way to the end. That's mainly for my benefit, so that way I don't have to think back and, oh, what was I talking about then? So we'll go ahead and get started. As Fuku mentioned, my name's Andrew. I run the legal Kokua line here at HAR. Brokers or principal brokers and brokers in charge can call, and I give legal information, not legal advice. So don't call saying that you got sued and you want me to represent you. But give me a call if you have some questions, and we'll go through some of the hot topics. These are pretty frequently asked questions that I get. I get anywhere from 70 to 100 questions a month. It's all seasonal. Some months are busier than others. Obviously, with coronavirus, things have been very, very busy. And on the topic of coronavirus, there's the few main issues we've been getting. The big questions have been about property management. There is the eviction moratorium that is in effect till the end of July. That's been pushed on and on and on as the governor's emergency proclamations have continued. So for now, it's July. I have no idea what's going to happen beyond that. I don't know if it's going to be extended through end of August, end of September, or if it will actually end at the end of July. Whenever that does happen, I can foresee the courts being swamped. Landlord-tenant court is already one of the busiest dockets. I've been in landlord-tenant court before, and if there was a day with 200 cases, that was a fairly average day. So I would not want to go to court if come August 1 if the eviction moratorium does end then. The other big thing with the eviction moratorium, or rather with the emergency proclamation from the governor, is that once that's in effect, month-to-month tenancies cannot be terminated. So if I was renting from you and I rented on a month-to-month basis, and you decided you wanted me out, you wanted to find a different tenant, you wanted to find someone who would sign a 1-year, 2-year lease, maybe obviously I haven't been paying rent because I lost my job, you can't actually end the month-to-month tenancy during this emergency proclamation. If it's a normal fixed-term lease, if it's a 1-year lease and it was supposed to end at the end of June, that's perfectly fine. It ends like normal. You can stop it, find a new tenant. But if they're on a month-to-month tenancy, you can't end it until the emergency proclamation ends. Now, if the tenant wants to leave, that's fine. If the tenant says, "Hey, I lost my job, I want to take off, I'm going to move back to the mainland," that type of thing, then that's totally fine. They can leave during the month-to-month tenancy. The other issues with coronavirus has been on the transaction side, the normal sales. And the big question I get is, can you show property with the tenants in place? So if you're showing a place that's being currently rented by tenants, can you say, "Hey, we need to, we're having some buyers come in, it's going to be an open house or whatever," and the tenants say, "Hey, I don't want people coming into my property because I'm afraid of getting coronavirus." As far as the emergency proclamations go, there's nothing that prohibits or changes the rules from the 2-day notice that's currently required for landlords to give tenants to go into the property. But I think you have to be reasonable. If it's an elderly person, and they're in their 70s or 80s renting a place, and maybe they're immunocompromised or things along those lines, and you're saying, "Hey, I'm going to have an open house," not an open house, showings, scheduled showings with appointments, with 10 people every weekend for the next month. I think that's maybe going to be difficult. Now, but then there's different situations. So I think really work with your tenants to try to figure that out, because this is going to be a tough situation. And obviously with the eviction moratorium, you can't actually get them out. So if you make it tough for them, it might become more unpleasant. Then the other question I get a lot is from the COVID-19 amendment/addendum. And that is the form that we made here at HAR, Standard Forms made at the very beginning and back in March to help our members address this issue. And this is for deals that are either in place, that were contract before coronavirus started, or other deals that are about to start. So you could use it either as an amendment to say, and this is more relevant probably back in March and April when you had deals that were already going and saying, "Hey, buyer lost their job because their restaurant shut down, so now they don't have any income, they can't qualify to purchase this property anymore. We're going to cancel this deal." And obviously there's financing contingencies in place, but maybe some of those timelines are over and the seller is willing to sit down and say, "Okay, I'm going to let this buyer go, and we'll find other buyers." And there's also a blank space so you can write in whatever, because we couldn't possibly fathom every possible scenario that comes up because of COVID. I think as time's moved on, from the calls I've been getting, a lot of companies have their own, a lot of the larger brokerage firms have their own COVID amendments and addendums. I'm not sure the exact percentage of what our form is being used, but it does seem to be used a reasonable amount of time. I think the other question that comes up is it required? And no, none of our forms are absolutely required. It's whatever buyer and seller can agree on. If a buyer and seller, and we talked about this in the creation of the form, a lot of sellers probably aren't going to want to have this form in the deal because it's more opportunities for the buyer to back out of the deal. And that's really something that the buyer and seller have to sit down and work with them to find out what they're both comfortable with. Just like any contract, it's the negotiation. So it's for us, it was mainly a starting point to go from. And with this pandemic, it seemed more likely that the buyer was probably going to have to back out of these deals. From the calls I've been getting, it seems like business is getting a little bit closer back to normal for our members. Deals are happening. I think, and as sad as it is, I think the people who have lost their jobs, who were going to lose their job because of this, have probably already lost their jobs. I don't know how many more are gonna potentially lose their job unless, you know, income continues to dwindle down in some of these businesses, especially the tourism-based ones. And speaking of the tourism-based ones, the vacation rentals have been prohibited, except I believe on Hawaii Island, they've been allowed to reopen. And when I say vacation rentals, I don't mean the hotels. I do mean short-term vacation rentals. But this is a county by county issue. So it may change as time moves on, as each island decides we're fine with opening up these short-term vacation rentals for inner island, or even potentially for people who are, who have already done the 14-day quarantine and then have moved forward. I think that may dramatically change too, if and when the governor announces his plans on reopening tourism, which is rumored to be this week. I've just read the same news that everyone else has, that they're kind of taking a look at what Alaska's been doing, which is a similar thing of, if you have a negative test within the last 72 hours, or if you land and take a test and it shows negative within 72 hours, then you can escape the quarantine. But we'll see. I don't know for certain what's going to happen. So let's talk about normal issues that I deal with, not COVID. Every time I get a call now that's not a coronavirus related call, it makes me a little happy, just because it's not something that I have to go back and read these emergency proclamations for. So a very frequent issue that comes up with disclosure in the purchase contract. You have to disclose the documents, and specifically the condo docs. And a lot of people have difficulties dealing with these associations. The associations give these websites that provide the forms, but the documents are out of date, or the seller says, well, I thought I had a different form before, or a different document, and now it's showing different on here. There's costs associated with it. And then the other issue is when the condo stock changed during the period that you're in contract. These are all difficult issues, especially because it really affects the timeline. Since if you get new condo docs throughout the process, that gives that disclosure period, that extends the time the buyer can back out. And because of that, I think the main issue is working to make sure that you're talking with the association, you're talking to the right people, and making sure that, before you even enter into contract, where to get the documents and how to get them. I think that the larger condo association management companies are doing a better job of communicating now. From my understanding, because of COVID, some associations were implementing new rules, new measures because of COVID. And I think that the associations have been slammed, and they're probably a little bit busy right now. So there may be some delay in terms of getting these documents or working with the staff. But that's something you guys can tell me more of. I would actually love to hear more about what's going on today. And moving forward with that, I think one of the key things you can do is, if the association's giving you some difficulty, a lot of times if you ask either the association management company or the association themselves who the law firm that's representing the association, you may be able to get the documents that way. And it may spur the association to be a little bit more cooperative too, if they know that you're willing to go out of your way to make sure it happens. And it is an important disclosure for the seller to make. And continuing on with the disclosure issues, a very, very, very common question is, sellers want to make sure that once the inspection is done, they don't have to amend their disclosure, the seller's real property disclosure statement anymore. So they all want to put language in saying that the inspection report is incorporated as an amended disclosure statement. Is that okay? The easy answer is no, that's not okay. The Hawaii Revised Statute 508D is that the seller must provide. So if the seller has to provide these things, it can't be the buyer providing it, obviously. Now, if the seller sits down, reads through the inspection report, which we can talk about a little bit more, whether that's a good idea or a bad idea. But let's say the buyer doesn't give the inspection report. Let's say instead the buyer says, hey, I think there's these 3 things wrong with your property. And the seller looks at it and goes, okay, I'm going to go ahead and amend the disclosure statement because it's a must. The seller shall amend the disclosure statement and sends it back to the buyer. There's these issues that now the seller is aware of, and so now that timeline started in terms of when the buyer can back out. But putting in language that the seller says, well, once you got that inspection report, consider that my amended disclosure statement, that's probably not going to work. And then it kind of also comes to that discussion of, should the seller ask for the inspection report? Should the seller's agent ask for the inspection report? And I think in talking with our members, talking through it on the standard forms committee and kind of seeing what the general practices, in a lot of ways, it's not a good idea for the seller to request an inspection report, because if there's 100 things potentially pointed out in the inspection report, and a lot of the things pointed in the inspection report is, there's chips on the paint, there's scuffs on the door. These are not material facts that are adverse to the value of the property. But if the seller is aware of them, does the seller need to disclose that? So that's probably not helpful to get the entire inspection report and have the seller sit back down, go through, amend their disclosure statement on every single point in the inspection report. Instead, working through and seeing, well, what are the buyer's big issues with it? Okay, we can go ahead and disclose these types of things, or having that communication. And then kind of the same thing goes from the buyer side perspective. If you're a buyer and you get your inspection report, there's this, and this actually comes up later in another point I'll talk about. There's this kind of idea that you can hide something back. You can hold something back and say, okay, well, I found these 3 things that were really wrong with the property. I'll just tell them the 2, and then that last 3rd one, I'll just hold in my back pocket until, we move forward and, oh, they're not giving me a price I like. Now we'll go ahead and say, hey, but there's this thing too. I'm going to back out of the deal. That doesn't work because of I-4 in the purchase contract. I'll go into more detail on that in a little bit. And then there's also the question of, what does the seller's agent have to disclose? If you walk into the property, maybe you have a seller that has never seen the property or hasn't seen the property in 10 years, is not physically present, and you're the one walking through the place, and the seller asks you, hey, tell me what's wrong with the place. And you say, oh, there's this leak, there's this, and the seller tells you, oh, well, don't tell the buyer that. Well, the agent does have a duty to disclose if it's inconsistent or contradictory to the seller's real property disclosure. So that's, really only if the seller says one thing and it's clearly not true, then you have to say something about it. But most likely in those cases, the seller is going to ask for help filling out the SRPDS anyways. The other questions, were there any, Crystal, were there any questions about disclosure?
I do have some, you kind of sped through.
I did, yeah.
Do you want to hold off and answer all of them later on, or you want to?
Sure. I'll take them at the end.
Okay, thank you.
So then the other question, and I've been getting this question a lot lately. I think COVID has kind of messed with people's schedules a lot. So people who buyers and sellers who are normally not at home all the time are probably all at home now, and maybe it's changed their schedules up a bit. And so a lot of questions about acceptance date. The client signed, the buyer signed the offer yesterday, but I didn't get it delivered to me until today. When's acceptance date? Or other issues along those kinds of lines. And if you accept a contract, if it's signed and both sides have signed it, but buyer sends an offer over to the seller, Seller goes ahead and signs it and accepts it, but doesn't give it back to the buyer. Buyer never knows that it was accepted. So it does require that delivery. And I think and I was talking with people about this, how does this even happen nowadays with DocuSign? You know, things get sent out immediately. Why is there this delay? What's going on? The answer turns out to be a lot of, you know, out of state mainland buyers, things like that, where they're either or not very technologically savvy, so they are physically signing it, or they're just in hard to reach places. But I think that the easy answer to this, in the lawyer's opinion, is you sit down with the other side right after everything's signed, delivered, you get everything, everyone's still happy with each other. Because I like to compare these contracts to a marriage. At the beginning, it's a honeymoon period, everyone's happy, everyone loves each other, everyone is willing to work together. And then as things goes on, things get a little bit more tense as all these issues arise. At the very beginning, while things are good, if you can at least both sides agree and say, hey, we're going to say today is acceptance date. So that way, all these new timelines that come from acceptance date, it's all based on today. You know, so it's not 2 weeks later where you're arguing, 14 days ended yesterday. No, it ends today for some of these deadlines. So instead, if you, at the very beginning, can sit down while everyone's happy and pleasant with each other and say, okay, acceptance date will be considered today or tomorrow, even though the signature dates may be different than that. This was in the next topic, paying commissions to agents, was in the most recent real estate bulletin. Can agents set up an S corp for tax purposes, and you pay the broker pays the S corp the commission rather than paying the agent directly. I think the real estate commission came out and said, no, you cannot do that. And if you read through the rules, it's pretty clear that the commission does have to be paid directly to the agent. And so because of that, you have to pay the agent directly. Then the agent, if they're going to move it into their S corp or do whatever, they have to do that on their own. Obviously, there's severe tax repercussions due to this. I've gotten some calls after that real estate bulletin came out that said, I'm going to have to change all the ways that I handle my payments. I hope not everyone's in that situation. It doesn't sound like everyone's in that situation. But that's the rules, and that's how brokers have to function and pay out their agents, despite what the tax professionals say. I will say I'm not very good with taxes. My wife typically handles the taxes for us, but I'm happy to help and try to work through some of these tax issues. But I have referred a lot of our members who call with tax issues to the Hawaii Department of Tax, and every single one has said that they've been pretty helpful when they call. You know, it's not like you're calling the cops on yourself. They're willing to talk and work through some of these issues. A real common question, and I think that this is really due to the time. A lot of times passed since you know, a lot of solar systems were installed during like a lot of the big pushes to install a lot of these solar systems on rooftops. And so a lot of houses now are selling that have these solar systems on. And we to reflect that in the purchase contract that we released last year, with the revisions in it, we added E3 that talks about leased solar systems. And to clarify that is only for leased systems. If it's an owned system, it's just counted as an inclusion in E2. But if it's a lease system, you're going to check that box off in 3, or if it's a power purchase agreement. If you have solar on your roof and you don't own it, you basically need to check E3. And then there's some documents that are going to come with that too. And I'm happy to take more questions on this topic. And I think it's something that the Standard Forms Committee is probably going to have to work through in the future, because it is an issue where if you have a lease for the solar panels on the top and you have to transfer that lease over, the buyer is going to have to qualify for that lease because there's a payment being made, and the solar company presumably has some sort of qualification system that they use in terms of knowing whether or not this new buyer should or should not have this lease system on there. I think in a traditional, financing deal, if they can't qualify for the financing, they probably can't qualify for the lease system. Maybe I'm wrong on that, but I think that's the general thought behind that. However, on some of these purchases, it would really become the issue if they're buying it outright in cash, and maybe they're not in Hawaii, maybe they're not even in America, so they're, for whatever reason, they have trouble qualifying for leases. That may come into question, and so we set up that timeline where, hey, you have to apply to qualify for this lease, get it transferred over to you, so that way all this timeline happens, so it's not something that's going to hold you up at the end of the deal, where, we're supposed to close tomorrow, but the lease hasn't transferred over. I'm not ready to move forward yet until I know for sure that I'll get to keep the solar system. Then the other change on the purchase agreement that was released last year, I think this is I would say I'm 100% certain it is the #1 question I get on the Legal Hotline, and it's, does the broker have to sign on page 14 of the purchase contract? And everyone says, well, why do I need to sign? But we made it to comply with the rule, and that's for the rule when the offer is being rejected. So say the buyer sends an offer over to the seller rejects it, but for whatever reason, the seller's not the one that physically rejects it and signs off saying that they're rejecting it. Instead, maybe you get a seller that just says, they're offering me $100,000 on my $1 million property. I don't even want to see it. And so they just kind of push that offer away. They kick it off to the side. And now the seller's broker, an agent, has to say, well, they rejected the offer. If you read through the rules, one of the Hawaii administrative rules, it says that if the seller does not, it's the offeree, the person receiving the offer, doesn't reject it, the broker does so in their place. And so we put that signature line so that way if the broker is the one who's having to go through and reject the offer, they have a place to sign to indicate that they were the ones to do it, not the seller. Obviously, some people have been using it for other reasons. If you have a very brand new green agent that still needs some supervision, maybe the broker's reviewing every one of their deals anyways, and maybe it's helpful for the broker to sign off and show that. Or from my understanding, there's some brokers that review every single contract and they want to show that, so that way they can show that, hey, I did review this deal and I feel confident in it for whatever reason. And then I-4. I get the occasional question on I-4, but I feel like I get questions on I-4 when I'm speaking to groups like this. Everyone seems pretty confident in their knowledge of I-4, but as we actually start going through it, it does get a little bit more and more complicated. I forgot to pull it up and put it onto the slide, but I-4 says that if the buyer discovers information that's contradictory to the seller's real property disclosure, they have 15 days to back out of the contract at that point. That starts the timeline right there, as soon as they discover it. So presumably they get the inspection report. It says there's a leak in the bathroom. Now, if the buyer then goes ahead and discloses that to the seller and says, hey, there's this leak in the bathroom, can you get it fixed before I take over the property, before the purchase goes through? And the seller goes, sure. The seller has to disclose, right? And they have to make an amended disclosure statement. So they go ahead and amend that disclosure statement. Well, depending on the exact timeline here, there's a different amount of time that the buyer gets to back out after receiving the amended disclosure statement. If that timeline is less, if you filled in I-4 that it's going to be 3 days or some other time frame, it's the shorter of those two time frames. So the buyer had those 15 days from the beginning. Say he told seller on day one, day two comes, seller goes ahead and amends the disclosure statement, gives it over to buyer. And they had put 3 days in there. Well, there's only 3 days now for the buyer to back out, not the full amount of time, not the full 15 days anymore. So it's the sooner of the two. Now, the flip side of that is maybe the buyer doesn't say anything. Maybe he just keeps his mouth shut about it and doesn't say anything about it. Well, he still has that 15 days. But this makes it important for the seller to give these amended disclosure statements if they have these different timeframes, because it gives certainty to the seller that when the buyer will back out. And again, I'm happy to take questions on it. I'm happy to chat more about it. It's a confusing topic, and we didn't choose that as the standard forms committee. It's the law. It's 508 D6 and 13. It's later discovered information. I can't remember the actual numbers now. And so those were the transaction issues. The other pretty frequent calls are the landlord-tenant issues. And yeah, okay, pretty much all of the calls have been COVID for the last few months. Prior to that, though, a lot of the landlord-tenant issues were medical marijuana in a smoke-free building. And so probably within the last 10 years or so, as medical marijuana has been allowed here in the state, a lot of buildings had a cigarette smoking ban in their building. So it prohibited, cigarettes and cigars. It didn't say anything about marijuana. So a lot of buildings instead set it up where it's a general smoking ban. It's not banning a specific type of, cigarette, cigars, marijuana, whatever. So instead it's a general ban on smoking in general. Well, people ask, well, Americans with disabilities, reasonable accommodation. That's been something I think that will be an ongoing issue as medical marijuana continues to grow here in the state, and as the laws continue to change for it, and as more prescriptions are given out for it. I think that there's no settled answer yet, except for that this is what I have been told from some of our members who have called with these issues, that they've asked the tenant to find some other way to consume the marijuana other than smoking, and working with them to figure something else out, because no one wants to be on the other side of a lawsuit when someone sues and says, hey, you're not giving me reasonable accommodation for my disability, whatever that disability is. And speaking of lawsuits for not doing reasonable accommodations, the other ones are these assistance animals. And so these just aren't a seeing eye dog, but these are also the emotional support animals. So the more general term for them is assistance animals. It's a common issue. I think almost every property manager has had to deal with this, where someone says, hey, I have this animal. I know the building says no pets. I know that the owners had no pets, but I still want to be able to bring this dog or this cat in because it's my emotional support animal. And yeah, you have to allow it. It's a reasonable accommodation. And so the rules from that go, it's not a pet. Do not use a pet addendum. And I'll talk about this in a little bit. The Standard Forms Committee is looking at creating an assistance animal addendum, because there are some of the rules that still apply to assistance animals, and damage caused by an animal, whether it's a pet or an assistance animal, is still the liability of the tenant. So if the tenant has an emotional support dog, and that dog goes ahead and tears up all the furniture in the house, or tears up the door in the house, well, the tenant's still liable for that. But obviously you can't charge a pet deposit. So how does that work? So we're trying to come up with a form that at least lays out what all of these obligations are from the tenant side, and also maybe what the owner can do to help protect him, whether that's insurance policies and other things like that. Because as much as the tenant's responsible for property damage that the animal caused, the tenant's also responsible for physical harm caused by that animal. So if a landlord knows that the emotional support dog is in that building, and the dog goes and bites someone and severely injures them, the tenant's going to be liable for that, but also potentially the owner. So we're trying to come up with a form and working with and talking to some of these civil rights groups to see what sort of form can we lay out that clearly explains what is and isn't allowed. And then this is the one our members least like to hear, and it's about personal transactions. So I think everyone knows in the normal buying, selling basis, if you're one of your agents, if you're a broker and one of your agents is buying or selling property out on their own, buying a property from themselves or selling their own home, the broker kind of has to supervise that. The broker is responsible for all of their agents in their real estate transactions that they're doing. And that includes their personal transactions. And that makes sense. If they're out there doing it for themselves, you hope that they're behaving well, just like they would if they were representing a client. Well, when one of your agents is leasing out their property, and even if a broker, and this kind of applies to the brokers too, if you guys do something in your personal transactions that is unethical, is against the Hawaii administrative rules, is against the law, your license can be called into question. But for the property management side, if you're leasing out property, it makes sense that your broker is going to keep an eye and make sure that you're following all the laws, you're following all the rules. But I've heard stories from people when they've been calling me with questions. Brokers are also responsible for the agents if they're leasing, if they're renting property. And for very large companies, that's almost impossible for them to really monitor. But for a lot of the smaller companies, just kind of having a good idea on what your agents are doing, maybe having a good idea if they rent or if they own, just to prepare yourself a little bit for what could happen. One of the things that we have talked about is for the leasing side, in terms of personal transactions. If one of your agents is leasing out their own property, and your brokerage firm doesn't do property management, maybe it makes sense for them to put their property with a property manager, so that way it's not the broker themselves having, the agent's broker having to review every single one of their leases. Instead, there's a property manager somewhere else with their own broker who does property management day in, day out. But the agent's renting a place, that is a very difficult issue. And I think we may, as we move on and as we start talking to the Real Estate Commission, we may see if we can get some clarification or some changes to it, because it's going to be impossible for a very large company to monitor hundreds of agents renting places, especially here in Hawaii, where I'm sure a lot of the younger agents rent. So real quick, I'm going to talk about standard forms. So I'm the standard forms liaison. This past May, we did have a release of forms. We didn't change any of the forms. The only form we were going to change was a rental agreement. And we thought the property management industry was having enough of a tough time with COVID that we didn't want to also say, and also figure out this new rental agreement, guys. So we held it off. It'll come out in the November release. Hopefully things have calmed down by then. It's tweaks. There's nothing I would say, we didn't radically change it. There is some parts about to clarify pets and animals and that type of thing in the rental agreement to make it a little bit simpler. But otherwise, it's not nothing crazy in terms of changes. We're currently we meet 8 times a year, and we've gone to Zoom as well and having our standard forms meeting. Maybe we'll go back to having them in person at some point. We're currently working on the seller's real property disclosure statement, and that's a really big form. I think COVID has maybe changed some of the questions. We may have some things that are related, maybe not to COVID specifically, but to other things that are kind of related in the periphery of it. Or maybe we will have to put something along those lines of, has anyone in your property been sick in the last 2 weeks or something along those lines? I don't know. That's something that the committee is going to have to discuss. We did finish the dual agency consent addendum, and that's for when the agents representing both buyer and seller in a deal. we're going to be putting it up for comment soon, and a lot of times I get calls from members and they say, why did you guys make the form this way? What were you guys possibly thinking? Well, there's about 16 of us in a room that sit around and make this form. I think everyone in the room is pretty smart. I don't know about myself, but I think everyone else, in the room is pretty experienced agent. They're experienced brokers. They have a lot of knowledge and expertise in this. And but there's always things that come up that we couldn't have possibly thought about. And so we send out these forms for comment. And so we can only we can only look at what the comments that come in. We can't possibly read everyone's mind. So when these emails come out saying, this form is being put up for comment, please read it and please comment on it, because that's where we get these thoughts, these ideas that come from outside of our group. And yeah, our group changes. We have different people that come and go, but really having feedback from people who never volunteer on an HAR committee, who don't even know what standard forms committee that it exists. Well, if they see this email and they go, oh, hey, this form's being changed. I don't really like that form as it is now, so maybe they made a change that I like. And maybe they can say that, or maybe they see the change and it's not what they like. So maybe you can go ahead and point out some things that you don't like about it. So I'm happy to take questions now. My number is on the screen. Again, principal brokers in charge can give me a call. I give legal information, not legal advice. I have an email address on there too. I typically don't respond to emails. I'll typically call back just because I'm a little afraid that people are gonna, forward my emails around and say, hey, Andrew at HAR said this. That's the law. I'm not making the law. I'm hopefully just helping everyone figure out what's going on. Crystal?
Thank you, Andrew. That's very informative. I just want to let everybody know that we're getting a lot of questions in both the chat and the Q&A boxes, and I have copied all of them into a Word document, and I'm gonna, we only have 15 minutes left to kind of go over some of your questions. Obviously, we're not going to be able to cover all of them. So what I'm going to do is I'm going to have Andrew take a look at every question, and he's going to answer them. And we're going to send that out to everyone who's attending today, so that you can see everyone else's questions and how they were answered. So Andrew, let me start with an early question that came, and it says, hot topic, STVR and lawsuit proposed by Elite Pacific Properties. We do have the standard form regarding STVR. So I'm wondering if you have had questions regarding the form.
So that form wasn't made by us. That was made by the Honolulu Board of Realtors. Since the vacation rentals is a very county by county issue, we don't make we try to make forms just for the entire state. So maybe down the line, as these regulations from all the counties kind of solidify and get a little bit more locked into stone, maybe HAR will create a statewide form to talk about vacation rentals. But I'm pretty sure the form you're talking about is an HBR form. So if you have questions, I would ask you to speak with them.
Okay. Next question. Even though pre-occupancy agreement is not mandated by Hawaii Landlord-Tenant Act, if a buyer defaulted, would the emergency order protect them from eviction if they refuse to leave?
Probably not. I think there are specific exemptions from the Landlord-Tenant Code for pre and post occupancy, which we have forms for both of. So this is where the buyer either wants to move into the property earlier, or the seller wants to stay in after the deal is closed. Both of those are exempted from the Landlord-Tenant Code. So it's going to be whatever's in that lease. And I don't see that. I can't see how there's anything. Maybe the emergency proclamation would still apply for non-payment of rent since it's eviction moratorium, but you could also potentially make the argument that it's not an eviction if it's not under the Landlord-Tenant Code. That I don't know. That's going to be something for lawyers to have to fight in court about.
Okay. I think this person just needs a point of clarification on I-4. It says, you said that a seller must amend based on what buyer informs from inspection. But then you said, then the seller amends and that's when the date starts. I thought it actually starts when buyer discovers per I-4.
So I think there's two issues in that question. The first one is the buyer doesn't have to tell seller anything, right? If they get the inspection report and there's 500 things wrong in the property, but the buyer is still willing to buy it and doesn't really care and just moves forward, they don't have to tell the seller, and the seller doesn't have to amend their disclosure statement at that point. Obviously, if the buyer goes ahead and says, hey, I think these things are inconsistent with your SRPDS, and the seller looks at it and either agrees, maybe they weren't aware of it, the home inspector went under the house, which the seller didn't do, or crawled into the attic and things like that, which the seller didn't do. Then the seller can go ahead and amend, and find something contrary to what their disclosure statement says. Then they go ahead and amend it. And it does say that they, when the seller is aware of this, that they shall make the amended disclosure statement. For I-4, when the buyer discovers this information, there's one timeline that starts. It's that 15-day timeline from when they discover. So let's take the inspection report out of the picture completely. Let's say the buyer goes ahead, drives by the property and sees a tree's fallen over onto the house. So now they're aware that there's something contrary to the seller's real property disclosure statement. 15 days starts from there. They could back out of the deal saying, there's material fact adverse to the value of the property that wasn't disclosed in the disclosure statement. But they call the seller the next day and say, hey, I noticed a tree fell onto the property. The seller is, wait, what? I'll go take a look. The seller goes by, sees it, gives an amended disclosure statement. And in I-4 or in I-3, and you fill in a different date there for amended disclosure statement. You put 3 days. The seller fills out and does that amended disclosure statement, gives it to the buyer. Now the buyer has the shorter of the two timeframes, either the 15 days from their discovery or the 3 days from when they receive that amended disclosure statement. So that's where the two timelines kind of come up. So it's not that they always get 15 days, it's that amended disclosure statement can also change the timeline.
Mm. Okay, I'm going to read one more question before we close today. And this question says, if buyer pulls out of the deal, gives inspection report to seller, can seller submit this report to next buyer as a supplement to their SRPDS disclosure form, I guess, or should they break it down in detail and physically change their disclosure statement?
I would be wary of giving another person's inspection report because that inspection report was purchased by the buyer. Presumably, and when I purchased my property, I found the pickiest inspector ever. He marked every single possible thing that you could find wrong with the property. How many of those are material facts adverse to the value of the property? Some of them, not all of them, certainly. And so if the seller is going to give out an inspection report that states all of these things are defective with the property, well, that's a lot of potential issues that could come up, down the line if something was disclosed, but it turns out to be even worse than it was disclosed on, or all these other potential issues. I think the seller should, if for whatever reason they do get the inspection report, look at it a little bit more critically and say, hey, and look at their current disclosure statement and say, hey, I said that the paint was fine in the property, and this inspection report says, there's chips here and there. Well, are those really all that different? I think taking a look at things a little bit more critically is probably helpful. And I know Crystal said that this is the last question, so I think if you have more questions, please give me a call. The number is on the screen. I'm happy to take your calls. And if you're not a PB or a BIC, you can call, and sometimes I'll listen to your question and say, well, talk to your broker about it. if your broker calls me, then I can go ahead and say, hey, I heard this question and I've already thought about it, or I've already kind of, you know, dug up the answer. So thank you so much, Crystal. Thank you, Fugu. Thank you, all the sponsors.
Thank you, Andrew. Like I said, I will be having Andrew take a look at all the questions that were asked today, and that will be sent out with a link to the recording of this session in case you were wondering about the recording. We will be sending it out. You can also access all the information from the REBI chapter's website at hawaiirebi.com. And mahalo again, Andrew, for being our guest speaker. Mahalo to our sponsors, Guaranteed Rate. Our next virtual GMM is scheduled for July 21st at 10 a.m. with guest speaker Denise Ma with Talent HR Solutions. And Denise will be doing a session entitled Considerations in Reopening Your Office. And our registration link will be found on our website as well. Stay safe and healthy, everyone, and have a great week. Mahalo.